Well, I mean, my topic, we don't have the pictures yet. It's the accumulation between copyright and that's it.
Where's the mouse?
Yeah, we have it.
Oh, there we go.
There we go.
This is much more boring.
Yeah, I'm very sorry. Although there are some pictures afterwards, so okay.
I need to step down.
I have a long title and maybe a long presentation. Hopefully, most of what I want to say has already been said, so I can be a little bit quicker, dealing with the merge between art and utility and the consequence for the coexistence of the different national regime. I'm coming from Belgium, and I used to note a system that I will present later, which is as well the French system of unity of art, which doesn't fit well with the UK system, and we'll discuss that more into details. To start with, okay. I want to start with some of the questions that were. Well, sorry, no, it's not that one, or.
Oh no, there's another one.
Oh, sorry. Oh, there. Okay, yeah. Good. That's too much now. Okay. Okay, so we have the outline. And I will skip it because there are many things that will be said later. So let's start with some policy question. The first one was asked to Arnaud Folliard-Mongiral. You might know him. He's working at OIM in Alicante. And he was asked which kind of IP reform he would like to see implemented. And as you can see, and it's a bit strange for a Frenchman coming from a country where you have full cumulation. But of course, he's working for OIM. So he thinks that the system of full cumulation seems to be quite anomalous. I mean, there is no sub-meaning in what I said about his working for OIM. What is the remaining value of design in a system of total cumulation with copyright? That was the question that Richard Arnold raised yesterday, and I wanted to maybe to answer it. I think that there are a lot of differences which do not make design still valid and attractive. But there are some peculiarities of design which I think makes a difference with copyright. And we can discuss that for later, but the presumption of validity for the registered design, for instance, is one. I think the fact that you have some evidence of ownership when you have filed and registered the design, while in the field of copyright you always have quite complicated ownership issues. And the fact that you can show the certificate, of course, it helps in practice. Of course, it can be used to do some form of IP bullying, but especially for a right which is not based on prior examination of the substantive condition. But it creates some kind of security, I think, for the right owner, at least. And of course, we have some procedural advantage. That was not much discussed so far, but with the community design courts, we have national courts with an international competence, and I think the possibility to get pan-European injunctions create, of course, value for design. We don't have that in the field of copyright. So I think there are still some advantages. I wanted to come back on to the principle of cumulation under international and EU law, but that has been already mostly covered. As you know, under TRIPS and under Berne Convention, different systems can coexist, either of a separation or partial or complete cumulation. Just to be reminded of the text of Article 2.7, which refers to the extent of the application of copyright and the conditions under which the works would be protected by copyright are left to the member states. As you know, and that was already discussed, we have the same language in Article 17 of the directive, which adds only that the level of originality required can be determined by each member state. So basically, there is broad room for possible divergence between the member states based on this Article 17, which reflects partly the international framework. Now, when you look at the recital 8 of the directive there, you have maybe the rationale, the justification for leaving so much room for member states. It refers to the absence of harmonization of copyright law, but that was back in the 19th. So my question here, and it's still a question, is this rationale still valid now after the 2001 InfoSoc directive, which has harmonized copyright? Some might say completely. I don't think it's the case, but and what is this rationale after the ECJ case law, which has harmonized, for instance, the conditions of protection through InfoPack and other cases that was already mentioned? Now, what do you have rules on cumulation on the EU side, on the EU copyright directive side? There is not much, but there is the possibility of a positive overlap with design rights when you look, for instance, at Article 9 of the InfoSoc directive, which is the directive is without prejudice to the application of other rights, including design. So we have numerous protections in the EU that was already mentioned. I don't have to list them again. We should not forget as well unfair competition, which is still possible in many countries, for instance, in France and in the Benelux. That makes, of course, a lot of rights. If we stick with EU law, I want to come back on some decisions of the ECJ. I think the case Totsiero, which involves the protection by copyright of shoes. I mean, we don't have any problem with shoes. Yesterday, someone said that, I mean, how can you conceive copyright on Crocs? Well, Totsiero is about copyright on shoes. Of course, it was about the issue of the former application of the separability criterion in Italy, where there was no possibility to get copyright protection at that time, and the application of the non-discrimination principle. So the conclusion of the court was, because there is some discrimination based on Article 2.7 of the Berne Convention, the reciprocity rule, there should be a possibility for TOTS to rely on copyright to protect the shoes in France. I think that was the case on the primacy of EU law over international law, over Article 2.7 of the Berne Convention. But of course, we have other cases which are mainly on the primacy of EU law over national law. We already discussed FLOSS, of course, and FLOSS might have consequence for the UK. That can be further discussed. Another case was already mentioned yesterday, and I'm coming quite late in the conference, so there might be some duplications. We discussed yesterday already the protection of GUIs, and there was one decision already mentioned by Annette, the BSoft case, which involves the protection of GUIs. Those are other GUIs, of course, which are involved. For those who were not yesterday, that was already shown. So that's one of the registered design that is involved in the Apple versus Samsung case. But the BSoft case was about the possibility of copyright protection for the graphical user interface. And as was summarized yesterday, the court said that you cannot use the protection of software, but it's possible to protect a GUI under the InfoSoc directive. In that case, the GUI would be considered as a graphical or as an audiovisual work. That might fit with some previous case law in some member states. Indeed, I'm not sure it's an easy solution. First of all, I would be a little bit critical about the use of a definition of computer program in order to exclude GUIs. It's a strange way, I think, for the court to come maybe to a good solution, but the court reasoning is that because a GUI cannot enable a computer to perform a task, it cannot be considered as software. So it's not software, but it can be protected by copyright. I think one of the consequences is that, well, it might become a little bit messy because we have two works which are ruled by different systems concerning copyright ownership. For instance, there is no works made for hire rule in the case of audio-visual or graphic works. It might create additional additional issues in relation to the private copying exceptions and the possibility of having levies. That's an issue which is discussed on the continent concerning computer games for years, for instance. If computer games, which have a strong GUI, of course, are to be considered as software, there is no levy. If they are an audiovisual work, they can be levied. So the discussion in BSOT might have broad consequence, as well concerning copyright contracts and more rights. So I think all those decisions might go into the right direction, but sometimes they create additional complexities into the system, which is already very complex. Another case that we did not discuss, the Peek and Kloppenburg versus Cassina case, which involves more traditional works protected by copyright and by design in a few countries. This case is about the scope of the distribution right. And in that decision, I think that the court applied quite a restrictive view on the notion of distribution, which would imply the transfer of the ownership of that object. In that case, it involves the shop in Germany, Peek and Kloppenburg, which had furniture somewhere in a rest area where the visitors of the shop could use them. So they had the right to use those works, and those pieces of furniture were as well visible in a shop display window. And the question was whether there was a distribution. The view of the court was, I think, rather restrictive there, with the requirement of a transfer of the ownership of the object. I think more a legalistic approach, while in a more recent case, which is interesting to compare into Usoft case, there the reasoning of the court is much more economic and ends up is a much broader view, I think, of the distribution. So how to reconcile that? National regimes on cumulation. Well, they significantly diverge. I will be short on the French system, which is the so-called unity of the art system. It's a system which is known for more than decades, more than a century in France. It means that applied art can be protected by copyright as well as the Beaux-Arts. So there is similar treatment. The consequence is that in France, copyright protection has protected what has been sometimes called the punniest production of the mind, les plus chétives productions de l'esprit. And you are using copyright. It's a little bit strange because you might consider that France had a very high conception about copyright. But when you look at the case law, copyright protects a lot of very, very utilitarian products. We have the same approach into Benelux, following a decision of the Benelux Court of Justice, because we have as well a Court of Justice for the 3 Benelux countries, which already in 1987 applied this notion of full cumulation to sunscreens in the so-called Screenoprints versus Citroën case. So basically, we had at that time a provision into Benelux law which said that only works having a marked artistic character should be protected or can be protected cumulatively by copyright on top of design. So you had those words, marked artistic character, and the Court of Justice of the Benelux in 1987 decided that it means only that you have to show the imprint of the personality of the author. That's sufficient to enjoy copyright protection. This provision then was repealed, and it's quite clear that we have since then, since the decision of the Court of Justice of Benelux, and more clearly now that Article 21 has been repealed, we have a system of full cumulation that is, of course, compatible with Article 17. The UK approach, of course, I won't say much. The system, the graduated or multi-tiered system into UK looks very, very complex to me. And I was really surprised by the Lucasfilm approach, considering that the Stormtrooper helmet is not a sculpture, because it's utilitarian, because it's used for the production of a film. For me, typically, such a helmet has a strong creative and expressive value and falls quite, I think, spontaneously within the field of copyright. At least that's with my bias of a continental lawyer coming from a full cumulation system. Now, there might be some collusion if you have a full cumulation system between the design and the copyright rules. So that's something, of course, to discuss. It's nice to have maybe on paper a full cumulation. There might be a lot of issues involving, for instance, subject matter. That has already been partly discussed yesterday. It's clear that copyright has a subject matter which is less tangible. It does not require a product. So copyright applies to something which is not as tangible. Concerning the subject matter of design, things are not that clear, of course, and Annette remember us that there is no decision yet of the ECJ. In the Benelux, we still have a decision of the Dutch Supreme Court in the Kinderkapperstoel case, which had a narrow view about the subject matter of design protection, because in that case, the owner of a design on a car model could not oppose the use of the same model to a completely different product, but the look was the same. It was a children's chair that you use to calm children when they have a haircut. So it's still an open question, obviously. When you look at the case law in to countries like France or Belgium, I think there is some form of attraction of the design approach concerning the conditions of protection within copyright. The notion of prior art, when you have a copyright case involving utilitarian products, usually or quite often is used. So the case law would say that originality should not be confused with novelty, but at the same time, they are assessing sometimes originality based on prior art. So it's a little bit strange, the reasoning which mixed the two systems, but I think that's a consequence of a full cumulation. We have a real problem concerning the ownership, because there is an ownership split system for copyright. It vests with the author, while in the case of works made for hire, the design right belongs to the employer. So that had to be solved, and the Benelux design law solved that by providing for a rebuttal presumption of ownership of copyright in the case a design has been filed on the same item. So in order to avoid some collisions. There might be other issues, of course, concerning the scope of the rights, because copyright, because it has a more intangible subject matter, can easily cover a use in another dimension. So from 3D to 2D or the other way around. As well, copyright provides for the right of reproduction and right of communicating to the public. One of the questions that might be discussed later is whether there is a reproduction right under design law. And there might be some arguments based on the exceptions, but that's probably a weak argument because there is an exception in the design regulation for acts of reproduction when they are made for citation or teaching. So some people derive from that the existence of a reproduction right is not that clear. So there are differences there concerning the scope of the rights. The scope of the exceptions, of course, might be another complex issue to solve. And if you have a full cumulation, you have that problem, clearly, with the list of 21 exceptions under the InfoSoc directive, while for design we have, I think, a mixture of copyright-inspired exceptions, like the exceptions for quotations and teaching, and we have patent-based exceptions, like the exceptions for experimental use. I think the issue of the scope of the right came to the front in one case that was discussed before the Dutch court. It's a so-called Dafonica or Plessner case, which involved the reproduction of this registered community design that Louis Vuitton owned on this graphic symbol, which is used, for instance, by Louis Vuitton for some of its handbags, which reproduce that design. The question is whether you see it here. The reproduction of this graphic design there on the back held by this young black child could be considered as a design infringement. I mean, I think that's really pushing design too far. So I'm coming here with a case which shows that design sometimes is used beyond the boundaries. There was an intention of the artist, because that's a painting. That's a painting of an artist called Plesner, and she wanted to show that, I mean, there are some people wearing Louis Vuitton bags and which are on the cover of magazine. Why not to have this black child for a case involving the disaster into Darfur? But of course, if you apply the rules concerning the scope of the design right, and that will be for the next session, I think, of course, that should not be an infringement. The lawyers used design rather than copyright, maybe because in the field of copyright you would more easily use the balance with freedom of expression or other exceptions in that case. To conclude, there is obviously limited convergence on the side of copyright when there is accumulation of protection, and probably there is a need to harmonize, but there is a real clash, I think, with in between the unity of the art approach that we have in different countries and the UK third system. Is it possible to control the collision concerning the different aspects I mentioned when you have accumulation of right? I think it's not an easy task. A better synchronization there should be organized. So what is the future? Well, the future might be that. In the UK, copyright protection for nursing bottles. That's what we have in the Benelux. Thank you.